SJC-11543, Commonwealth v. Matthew J. Sheridan.
Good morning.
Good morning, and may it please the court. Paul Rudolph on behalf of Matthew Sheridan, the defendant appellant. To uphold the police actions in this case, ordering Mr. Sheridan out of his minivan, pat-frisking him and searching his person, handcuffing him and physically moving him away from his vehicle.
Is the pat-frisking an issue here?
It's not. What I would say was a search of his person when they took out the money and counted it is arguably an issue in that the Commonwealth relies in a small part on that to argue probable cause. But what they ultimately did after they handcuffed him and moved him away from the vehicle was they actually searched the vehicle. Those actions, based solely on observing what appeared to the police to be a single-ounce bag of marijuana.
When you say search the vehicle, did they do anything other than to lift up the T-shirt and seize the bags of marijuana?
They did two things. They entered the vehicle, which under Commonwealth versus Podgorski, a case in which an officer simply stuck his head through an open door of a van, is a search. In this case, they went beyond that. They actually entered the minivan. That, in and of itself, is a search, and lifting up the shirt is a further search. Based on observing a single ounce of marijuana.
Wait a second. Based on observing?
Yes,
Single ounce. So this is established it was a single ounce.
That's what they said.
both officers testified.
It was consistent with a single ounce as far as they could see.
Correct.
Because it was partially under the T-shirt.
Yes, but that didn't seem to affect their assessment, their belief in what this bag contained. They both said.
So they saw that. It seemed to them to be consistent with a single ounce.
Correct.
The defendant denied there was anything in the car that was illegal. Now they have a conflict here.
Correct.
Okay.
And that observation alone, as this court said in Cruz, as this court has said in basically 6 cases following Cruz, does not justify the intrusive conduct that the police engaged in this case.
So let's go forward. Let's assume that there's a stop of a car for a traffic stop. During the course of a discussion, he says, "Officer, I've got 0.95 ounces of marijuana," and it's sitting right here on the passenger seat. What is the officer supposed to do?
Well, what the officer is supposed to do is tell the individual, I'm issuing you a civil citation, and you're subject to paying a $100 fine, and the marijuana is subject to forfeiture.
Not
so
give
would
me
you,
the marijuana?
Would you please hand me the marijuana?
Okay, so
And I would say in probably 99 out of 100 times, the person's going to hand over the marijuana.
so you're saying the appropriate course of action is to request the marijuana to be handed over?
Which never happened in this case.
I know.
Okay.
And if the person were to say, "I prefer not to do that," what happens then?
Well, again, didn't occur in this case. so it's
I'm
not-
aware of that. I'm just
Yep.
trying to figure out what you say to be the
I
appropriate limit.
I would say that the police are probably entitled to order that the person hand over the marijuana. But what they're not permitted to do is commit the type of constitutional intrusion by entering a car, entering a protected space in order to seize it.
Well, in those circumstances, wouldn't the police have a basis to believe that there might be more than the, quote, legal amount in the car?
The court has rejected that repeatedly.
Well, no, have they really rejected that? I only have an ounce in a car, Your Honor. Well, your officer. Well, then please hand it over. No, I'm not going to hand it over. No basis to believe maybe there's something else also being concealed? Maybe it's more than an ounce?
No, I don't see why that would give rise to a reasonable belief that there is more marijuana in the car. I think actually probably the opposite. I mean, if somebody has more in the car, I would think their instinct would be to say, yep, here, take this non-criminal quantity of marijuana to avoid the type of situation that Chief Justice Gantz is raising, which is the risk that the police might actually enter the car and find more. So I would suggest that no, that does not give rise to a reasonable belief that the car contains
Unless
more
there's
than 1
something
ounce of
more.
marijuana.
You're just saying it would need, if you added other facts, okay, but just on itself, it isn't enough.
Yes, there could be other facts, which it's always a fact-bound analysis, but
So,
the
but-
facts in this case didn't give rise to that
But
basis.
what I'm not clear about, and maybe because you're seeking to avoid being clear, is I understand you're saying the first step would be, please give it over. Second step would be, I order you to give it over. And if it's still not done, would you say that the police officer would then have the ability to enter to seize it?
No, I would not.
Okay, so you would say you can't seize it, period. All you can do is ask and/or order.
I think in certain circumstances, arguably the police could seize marijuana. If it's sitting on a park bench next to the person,
But referring to a car or, so
car?
you said there's no ability to enter a car to seize a forfeitable amount of marijuana.
if they could enter a car to seize a forfeitable amount of marijuana, they could just as easily get a search warrant to enter a home where they see a non-criminal quantity of marijuana on a kitchen table through the window of that home. And this court in Cruz made clear that you cannot obtain search warrants for the purpose of seizing evidence that is a contraband that's not evidence of a crime. It would be contrary to Article 14, and it would be contrary to one of the clear purposes of the Decriminalization Act, which
Well,
is to limit police authority in this arena.
Could the police hold the car and then apply for an administrative search warrant because the defendant was in possession of a civilly violating quantity of marijuana?
It's a good question, Justice Spina. I don't know if they could hold the car. I do think they could probably initiate some type of in rem proceeding. Whether that, without holding the car, would be effective, it probably wouldn't be.
One would think by the time it got filed, this marijuana would have dispersed somewhere.
That might be the case, although I suppose the officer could inform the individual that I'll be applying for a court order, civil order for the forfeiture of the marijuana, and a violation of that order could be deemed an act of contempt. Some people might comply with that. But again, I think we're probably talking about an incredibly small class of cases here. I think a request to hand it over is going to take care of this issue, and that's really what they meant by subject to forfeiture in the language of the Decriminalization Act.
The Commonwealth argues that what the police officer said was that it was about an ounce, and that has the implication of more as well as less. And on the basis of the implication of more, that what followed was justified.
The Commonwealth argues at page 12 that there was probable cause that the amount of marijuana could be a criminal amount based on the word about, essentially. That's not the standard. The standard is what this court just recently articulated in Overmeyer in your remand order, which is that the officers have to have a, quote, reasonable belief that, in that case, what the officer called the fat bag contained more than 1 ounce of marijuana. Not might contain or could contain, but that it did contain. In this case, both officers said they were trained specifically to recognize a 1 ounce bag of marijuana, that this bag appeared to them to be consistent with, yes, they used the word about 1 ounce of marijuana. And Officer Glennon actually described it in answer to a question from the Commonwealth at page 15 of the transcript as a 1 ounce bag, which is also how the motion judge described it in his findings. The first person to characterize this bag in the terms of more than or possibly more than an ounce of marijuana is the assistant district attorney handling the appeal in her brief. No officer used that language. The motion judge didn't use that language, and in fact, the trial prosecutor at page 62 argued that both officers testified that the amount of marijuana was, quote, where they would expect it to be if that was an ounce of marijuana. I think, if I could just quickly draw, I think what it's a helpful analogy to show why this is not sufficient to meet the probable cause standard. If the Commonwealth were to seek an indictment for trafficking in heroin, which requires probable cause to believe that the weight of the heroin is at least 18 grams. And an officer, the only evidence presented to the grand jury was testimony of an officer who said, I am trained to recognize that it's common to package heroin in 17.5-gram bags, and I'm trained to recognize that. And I observed the defendant in possession of what appeared to me to be about a 17.5-gram bag. I don't think that anybody would possibly suggest that that testimony would be sufficient to sustain an indictment for trafficking. It's the same standard. It's a probable cause standard. The testimony here was not sufficient to meet the probable cause standard. And I also think that the footnote this court wrote in Cruz, footnote 25, is pertinent to this question, because in that footnote, the court said that in light of the widely publicized nature of the decriminalization initiative, quote, it is even more likely than before that persons will take care to restrict possession to 1 ounce or less. So if there's any inference to be drawn from seeing what appears to be an ounce of marijuana, it's that it is an ounce or less of marijuana, not more. So in this case, the two arguments that the Commonwealth advances in their sort of never-ending quest to get around this court's holding in Cruz, one, that there was probable cause to believe there was more than an ounce. They did not sustain that burden based on the testimony of the officers and the finding of the motion judge. And two, that the police are allowed to effectuate a seizure of the non-criminal quantity of marijuana. Those arguments both fail. The second one, because they did far more than simply seize the amount of marijuana. The police far exceeded that authority, pulling him out of the car, pat-frisking him, searching him, handcuffing him, moving him away from the car, and entering the car, which is a search, lifting up the T-shirt, which uncovered the additional bags of marijuana, a further search. That incredibly intrusive conduct runs contrary to the purpose of the Decriminalization Act, and it is in violation of Article 14, as this court has construed it in Cruz, in Kiefner, in Daniels, in Jackson, in Pacheco, in Cran, and in Overmeyer. To now say that the police can enter a car, can issue an exit order, can search a person solely so they can seize a non-criminal quantity of marijuana.
Was this a non-criminal quantity? This was a criminal quantity, as it turns out.
Only after they discovered 2 additional bags.
How much was in the bag, by the way, how much was in each bag?
So there was no evidence presented at the motion hearing as to the actual weight. The testimony was that one of those additional bags appeared also to be an ounce and the other one appeared to be smaller. So in total, we're talking about a little bit more than 2 ounces, maybe 2.5 ounces, something to that effect. But there wasn't evidence as to the actual weight. But to find that the police conduct in this case is permissible so that they can seize what at that time appeared to be a non-criminal amount would effectively eviscerate this court's holdings in Cruz and all of the cases that have followed Cruz since then.
Now, am I correct that that marijuana is not sui generis in that there are other civil forfeiture provisions in law? There are other things for which the possession is illegal but not criminal? Or is this simply a new area that we need to work out by itself?
I'm not aware of any specific examples. I've thought about it. I haven't come up with anything that is a good analogy. There are other items, such as hypodermic needles, that are legal under some circumstances and illegal under other circumstances. Marijuana actually is now legal under some circumstances, under the medical marijuana law, and illegal under other circumstances. But as far as I know, it's sui generis. But again, this court said in Cruz, in order to conduct a search, it has to be for evidence of a crime, not evidence of something that is civilly illegal, if you will. And so I'm asking this court to continue to follow the rule that you that you articulated in Commonwealth versus Cruz and all of the cases since then, and to find that the conduct of the police in this case violated Article 14, violated the Fourth Amendment, and therefore the ruling of the motion judge denying the motion to suppress must be reversed. Thank you.
morning, Your Honors. Pamela Alford for the Commonwealth. I'd like to start with a factual correction on whether the amount of marijuana was contested below. In the judge's rulings on page 40 of the Commonwealth's brief, the last line, the judge found in his written findings, the issue of whether the police could ascertain whether the initial bag of marijuana, because it was partially hidden, contained more or less than 1 ounce of material was a contested issue at the hearing. The judge then found that irrelevant because he relied on forfeiture grounds. So it was raised. That there was inconsistent testimony, but there was certainly testimony for which you could find that the officers consistently said about an ounce, approximately an ounce. Because this is what police officers do. These are real-time decisions where police officers are trying to ascertain whether there is a criminal amount of marijuana. Second, I'd like to challenge the defendant's argument about the line of cases beginning with
Can I just
Kiefner.
pause you right there? I mean, if it's at about an ounce, then it's not a crime, right? So wouldn't they have to say it was at least, or it was over, it was more than, I mean.
No, in this
So
circumstance.
it's okay to say, I'm not sure, it might have been under an ounce, but could have been more.
The Commonwealth's position is that it meets the definition of probable cause, that there are specific facts here that you have a partially hidden, a partially covered bag that could be a criminal amount of marijuana.
That's not what the officer said.
Excuse me?
He said he could see the bag.
He could, Trooper Walker said he could see the majority of the bag. It was partially hidden, and both officers testified that it was consistent or about approximately with what in their training and experience after the 2008 initiative petition was about an ounce of marijuana. The Commonwealth contention is that's probable cause, that that's a criminal amount of marijuana, that those are specific facts that a police officer, given the circumstances before him, would think that a crime is in progress.
How is that consistent with what we said in Overmeyer?
Because in Overmeyer, and indeed in all the cases that the defendant cites, there's a critical distinction. And the critical distinction is the search of the vehicle, the general search of the vehicle, was based on either a smell, burnt or unburnt, of marijuana, or on the possession of marijuana that was clearly under an ounce that the police already had.
What about the
The
fat
fat
bag
bag.
in Overmeyer that the judge didn't make, and there were no specific findings about how much? It couldn't be just left to might be, could be, you know, it was a fat bag. That wasn't enough.
Well,
So how is about an ounce enough?
My understanding, Your Honor, in Overmeyer, and again, this court's decision, but in Overmeyer, my understanding was this court remanded Overmeyer precisely for that purpose.
Because it wasn't established below.
Because, again, my understanding is a fat bag is different than officers' testimony that in their training and experience, they saw a partially covered bag of about an ounce.
Yeah, but
that is a more specific fact than a fat bag.
But it wasn't the generalized training and experience that you normally hear from a police officer. These officers had gone to the American Institute of 1 ounce bags, whatever it's called. And they said that this was 1 ounce. I mean, he put his reputation on the line. It wasn't about an ounce. He said that this was a 1 ounce bag of marijuana, which is insufficient.
Excuse me, Your Honor, I would rely on, page 14 when the question.
14 of what?
Page 14 of the transcript, where the question was about how much volume-wise, how large was the quantity of marijuana that was visible outside the T-shirt, if you remember. I would estimate it was the corner of the bag that was visible, consistent with about a 1 ounce bag. The depth would be about the depth of about what it would be 2.5, 3, 4 inches, whatever it is, 4 fingers. The corner of the bag was exposed. That was Officer Glennon's testimony. Trooper Walker's testimony. Trooper Walker was the first person to see the bag. He testified first that the starting on page 46, the state police have trained us to identify about an ounce of marijuana is the same as a dollar bill. And then he says on page 48 that it was approximately, in referencing the marijuana, it was approximately the size of a dollar bill. It is correct to say that there were questions that were, and answers that refer to it as a 1 ounce bag, but there are certainly the officers in testifying as to their observations testified to an amount that could be a criminal amount of marijuana. And for that reason, there was probable cause to search, or at the very minimum, reasonable suspicion to constitute an exit order. And from there, the stop continued to devolve. The Commonwealth certainly recognizes what this court said in Cruz about nervousness, but you have rapidly progressive shaking, and when he's asked, and this is another distinction from the other cases, and particularly where the defendant argues the issue of notice, that we should infer that people will keep under an ounce of marijuana, that we should infer that people will just hand it over. Well, in the cases cited in Pacheco, he's asking, are you smoking marijuana? Yes. In Daniel, he's handed over 2 bags of marijuana. Here the officer says, is there anything illegal, anything I should be concerned about? No. And when he said, I found marijuana in the vehicle, the defendant slumps. They also find, and I believe it's at page 11, what's testified on direct and then clarified on redirect, a large amount of cash on the operator. So there are additional facts here after
I agree with the large amount of cash thing, but how did they get the large amount of cash? I don't really understand the pat frisk thing here. Where's the justification for the pat frisk? They pull him over for a motor vehicle violation? They pat frisk him?
Well, because at that point, Trooper Walker had seen what could be a criminal amount of marijuana in the vehicle.
All right, so he's taken out of the vehicle before there's an observation of the marijuana?
No, we have two officers here. We have Trooper Walker,
Okay.
who was not following behind.
Give me the sequence. I understand
Okay.
they're two different
So Officer
police.
Glennon stops the defendant for having a headlight out.
Right.
Trooper Walker happens to be passing by, Police Trooper Walker pulls over to assist. Officer Glennon approaches the officer's side. He sees the defendant, gets license and registration. It takes several attempts to get a registration, makes a finding that the defendant's getting nervous. By the time he hands over the registration, is shaking almost uncontrollably. Meanwhile, Trooper Walker goes to the passenger side.
And then says weed or something like
Yeah,
that over
he
the
sees
top
it's
of the car.
2:50 in the morning, the flashlights. He sees what he believes to be a partially covered bag of marijuana. You can see the
So is this
majority of it.
So he's then taken out of the car.
Then he is taken out of the car.
And pat frisk.
Yes.
So the pat frisk is what? Incident to an arrest? Has there been an arrest at this point?
Well, I think at that point that they're investigating the marijuana that Trooper Walker has observed in the vehicle.
He's not in the vehicle.
What?
He's not in the vehicle.
He's not, and I do want to make that clear. Trooper Walker's observations of the marijuana occur when he's outside of the vehicle. Officer Glennon, and to the extent that there is a contested factual issue, it does appear that Officer Glennon, when he's testifying about the T-shirt, has opened the door of the vehicle. But Trooper Walker's observations of the partially covered bag of marijuana occurred in plain view. And
Yes,
so,
but they didn't know that there was more than that until afterwards, until they moved the T-shirt.
they didn't.
Did that happen in conjunction with having the defendant hauled out of the car?
Well, once the defendant left the vehicle, and it is clear from the record that they tell him that there's marijuana in the car, he slumps, they do put handcuffs on him, that the decision to make the search is at that time.
And that's before they've seen the rest of the marijuana.
That is correct. The
Right,
rest of the
so if they're searching him and they're getting the cash, and that has yet, something else is going on at that point on the other side of the car. So it's not like they've got the extra marijuana as something that precedes the search of the frisk of the defendant.
That is correct. But that goes to show the limited nature of the officer's actions. They weren't, as in the rest of the
Cuffing
cases, the
him
defendant,
was a limited action?
Pulling him out of the
because they
car
were
and-
looking just to get them what could have been the criminal amount of marijuana or the marijuana subject to forfeiture under the initiative petition that they
Cuff
saw in
someone?
plain view.
You handcuff someone for a civil amount, a civil forfeiture?
It's Commonwealth's position that that it could have been a criminal amount, that it was an appropriate step in the officer's investigative conduct, given the evolving nature of the stop, to investigate what could have been a criminal amount of marijuana.
Let's imagine that there's no dispute that it was below 1 ounce. Let's imagine it was 1/2 ounce. It had 1/2 ounce on the bag. Everybody agrees it's 1/2 ounce. What do you say is the ability of an officer to seize that bag from inside the car?
Certainly, the Commonwealth would suggest that by the end of the stop, the officer should have the bag. The idea that the officer can just ask and be told no completely undercuts what was in the initiative petition, which was presented as I would suggest to get the votes as a balanced. Or what was perceived by the advocates of the initiative petition to give some assurance to those who might be against it that people weren't going to just walk off with the marijuana. So the officers, that 32L clearly states that the marijuana is subject to forfeiture regardless of, 32L says under an ounce of marijuana is subject to forfeiture.
So you would say that there is at least an automobile exception to the administrative warrant requirement.
Yes, and I think I do think that that's clear. I think there is a difference between automobiles and houses in this circumstance, because there is heightened exigency in automobiles because that marijuana is going to go away immediately, and that is just another part of the long-held automobile exception in this country and in this Commonwealth.
So if he walks by someone's house and through the window sees them smoking marijuana, you say they cannot enter the house to seize it, but they can get an administrative warrant to seize it?
I would think that would be a different. I think that would be a case for another day. I think that in terms of if you look at, I cited Commonwealth versus Tart in my brief, that in terms of proportionality and the need for the intrusion, the need for the seizure versus the proportionality of the intrusion, where there is the long-held exigency of automobiles, and the officer has the burden of upholding 32L, which says that the marijuana is subject to forfeiture. He can make a limited intrusion to seize the marijuana in the vehicle.
What does that mean, to have it be subject to forfeiture? Does that mean it could also be done by virtue of a citation that issues?
I would suggest that given the combustibility of marijuana, it doesn't mean that. Particularly where I think it was, where you could infer it was put into 32L as a check or balance as to what people might see might be the untrammeled decriminalization of marijuana. I think it means you lose the marijuana immediately when you are issued the citation.
Would you agree that as a matter of, we'll call it proportionality or whatever, that step one would be for the officer to essentially say, hand it over, as opposed to, I'm now going to search your car and seize what I can find?
I think it is. I think that it is fact specific. I think that it depends on the circumstance.
Take these facts.
Okay.
Take these facts. Why could he have not just said hand it over? And that, at the very least, be a prerequisite to an entry.
The officer did ask if there was anything illegal in the car, anything he should be concerned about, and he was told no.
Well, he could say, he could follow up on that, as opposed to getting the person out of the car. He could say, well, looks like I'm looking at marijuana. Is it? I mean, he could do a lot of things other than what he did.
And he did tell the defendant that they observed marijuana, and at that point, the defendant just slumps.
He was out of the car, right?
He was out of the car at that point, yes, Your Honor.
So should there not, at the very least, in order to minimize the intrusion, as Justice Cordia asked, be a requirement to at least say, hand over that marijuana, and if you don't, then I may enter your car to seize it?
I think that it would be a fact-specific inquiry, and in this fact,
Take
the
these
officer...
facts. On these facts, is this so dangerous a desperado that he needs to be pulled from the car, frisked, because he has a 1 ounce, maybe a little bit more than a 1 ounce bag?
It is the Commonwealth's position that this was a limited intrusion that was reasonable in the circumstances.
Okay, but you didn't answer my question. Are you saying in this situation it was unreasonable to ask the police officer to say, hand that over, and if you don't hand it over, I will go in the car and get it?
That would have been another option, but does not make the officer's conduct unreasonable in this circumstance.
Thank you, counsel.
Thank you.